On this morning's Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thank you.
All right, let's get to it. And I want to do this first because I know we're going to get going on our conversation and I will forget to give the proper time to it. As a matter of fact, later this week is the first of the two summer conferences being put on by Washburn Law School, and it's got a focus on farm income taxation as well as farm and ranch estate business planning.
Right. Later this week, Thursday and Friday, we'll be in Petoskey, Michigan. So if people are familiar with how Michigan looks geographically, the Lower Peninsula is often referred to as a thumb. And we're going to be clear almost to the very top of the thumb, the Lower Peninsula, almost up to the bridge at Mackinac. Very lovely place. In fact, that's one of the areas of the country. In fact, it might be the leading area of the country in terms of cherry production. There may be a couple of other areas that dispute that, but a lot of cherry production up in that area. Very beautiful area, a lot of forests. In fact, there had been a recent fire near Gaylord, Michigan, a week or so ago, but that's controlled now. But you're right, that's coming up later this week. Thursday is all farm income tax. Friday is all farm estate and business planning. And on Thursday, we'll have a presentation by the leader of IRS Criminal Investigation Division on security, and she's going to make a presentation on how tax professionals can protect their practices from scammers, and how the IRS. She gives a great presentation on how IRS finds the tax fraudsters that are out there. It's very interesting.
And of course, we've talked about your second one as well, coming up in the month of August out at Coeur d'Alene, Idaho, too.
Yeah, that's one of the most beautiful areas in the entire country, in Coeur d'Alene, and we'll be there on August 7 and 8. And that is a dual-track seminar. We'll have the standard tax and estate and business planning track for 2 days, but simultaneously running in another ballroom, we'll have a track focusing on ag legal topics. So we'll get into, and I'll bounce back and forth between each track in terms of speaking. But we've got an economist coming in talking about current economic trends. Of course, I'll do an update on what's going on in the courts with respect to farmers and ranchers. Because we're out west, we're going to focus on some grazing issues on BLM land out west. And we've got a presentation by not only a farmer and a rancher from the state of Washington in terms of how he uses tax professionals and legal professionals to help him with his business and why that's important, but also a seasoned rural attorney who also is going to give us his perspective on how to retain young lawyers, how to find them in the first place and retain them in a rural area to provide legal help for farmers and ranchers. Then we have Damian Schiff, who was the lead counsel on the Sackett case that was recently decided by the U.S. Supreme Court. He's going to talk about the case and the implications going forward. We'll have a banquet that first night, and Damian will be at that banquet. We're trying to see if the Sacketts themselves can come down to that banquet. We'll have an hour of ethics on that one, and then on the second day, I'll lead it off with a discussion of the foreign ownership of agricultural land issue that's been in Kansas as well as other parts of the country this year and the past year in particular. We have a session on immigrant labor and ag, animal welfare, and the legal system, and a wrap-up session on everything to do with agricultural leases. So that's the dual track, focusing on ag legal topics, running simultaneously while the tax and estate and business planning track is running.
Now, if you can't make it to Petoskey, Michigan, coming up later this week, or Coeur d'Alene, Idaho, August 7th and 8th, Roger, both of these summer conferences can be found online as well.
That's right, yes. And people can go to my website and find the registration links and more information about the conferences. Plus, I just posted a blog article yesterday that has the links in there, too. And I tease that out on Facebook as well as on Twitter.
All right. I wanted, like I said, wanted to make sure we got to that before we got deeper into the discussion. Now, we've got several topics we want to talk about, and if you heard this morning's agricultural law and tax report, you talked about this as well, and obviously we're coming up on fair season, and well, if you're 4-H or FFA and you had an animal that went through the auction or soon to go through the auction, question is on proper tax reporting on that.
Yeah, that's right, and that piece did come out this morning. Of course, I record the daily shows in advance. I wasn't. I heard that this morning. I was, it was just kind of by coincidence, and we'll talk about this again. But this is some of these topics that I talk about. I time them because they are timely in certain parts of the year, and that's why I wanted to bring up this 4-H FFA project piece now, and why it's running on the daily program today across the country. In terms of the proper tax reporting of that when those animals are sold. Now, of course, it's income, but the question is primarily, is it subject to self-employment tax? And the answer is it depends. It is subject to self-employment tax if or let me start this way. It's not subject to self-employment tax if the animal was raised for educational purposes. If it's primarily raised for educational purposes, you're not raising it for profit, you're raising it under the rules of the sponsoring organization, whether that's 4-H or FFA, then it's not subject to self-employment tax. Now, that also means it's not earned income, because it has to be earned income to be subject to self-employment tax. So if it's not earned income, it's also not earned income for what we call kiddie tax purposes. And that's good, because if you have too much earned income as a younger person and their age cutoffs with respect to that, then you can have some of that income taxed at the parent's higher rate. So it's not you've got a double benefit there, no SE tax, and it's not earned income for kiddie tax purposes. But if you raise the animal as part of an activity that you're engaged in on a regular basis for profit, then you need to report that on the Schedule F. And if you have some of the kids that are in 4-H are also engaged in their family's farming operation. So if it's a farm animal and it's raised as part of that farming activity, you're going to need to report that on the Schedule F. And if you have a separate farm activity, then it's going to be Schedule F income. And that means it's subject to self-employment tax because it's going to route through the Schedule F. Also, there are other things to think about when you sell the animal and you're doing some tax planning. Now, often we don't think about doing tax planning when selling a 4-H animal, but if you want to start an IRA, you have to have earned income. Well, earned income means you're going to have to pay Social Security tax on it, the self-employment tax on that. And another question that might come up is, do you need to earn credits for Social Security purposes? Well, if so, you need to pay self-employment tax on that. So there are some other things to think about with respect to this. So just raising that issue so people are giving some thought to that and to make sure it gets reported properly when those animals are sold.
Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, is joining us, and we've got several topics of discussion this morning. Another one that obviously is very important is checking your beneficiary designations, or in this case, the importance of why you need to keep a constant check on those beneficiary designations.
Yeah, that's right. And you sometimes see cases on this, and probably see 3 or 4 of these really big ones a year, and we just had another one out of Iowa. This person had over $3.5 million in their IRA at the time that he died, and he's survived by his wife and 4 children. And his will said that his IRA funds were to be used to provide for his widow during her life, and then go to a family trust for the kids. Well, when he executed his will, he also signed a new beneficiary designation form that designated his wife as the primary beneficiary. So all is fine up to that point in time. 4 years later, he writes out a new will and said the IRA would be included in the marital trust created under the will if his estate wasn't large enough to trigger any federal estate tax. And that's a fairly common clause that's used in a lot of wills and trusts. And then the balance is passed to the kids when his wife dies. Well, he didn't update his IRA beneficiary designation to denote that change. And when he died, everybody was good with it, except, of course, one child. And he claimed that his mother the widow, his mother, shouldn't get all the IRA funds, and he claimed it should go to the family trust to benefit all of them. And so this ends up in litigation. It goes on for several years. Ultimately, the court said the IRA does go to mom, but it's very important when you have documents that are not going to go through probate, that they have a beneficiary designation on them, that you pay pretty close attention to the details when it comes to beneficiary designations and your overall estate plan. And had he spent a little bit more time paying attention to that, it would have avoided some heartburn for the family.
A silly question to ask on that: is it more of the responsibility of that person to tell whoever is working on their, on their will, to say, here's the situation? Or does it go the other way, that the lawyer should have reminded him, or whoever, the attorney that was working on that, or does it depend on the situation?
Well, it might depend on the situation, but I would throw both parties under the bus on this one. As the professional that is advising the individual here working on the estate plan, you need to take a look at all of their assets that they have and make sure that the beneficiary designations are coordinated with what you're doing in terms of drafting the will or the trust provision. Something slipped through the crack here. All the parties are responsible here, and maybe each party thought the other one was taking care of something, and of course nobody did anything in that instance, and it created a problem.
Yep. Okay. All right, let's go on here. Another part of this we want to discuss is concerning liability release forms. And I like how you lead into this story in the fact of, do they work?
Well, and again, the answer is depends. If you're in Iowa, the answer is no, because there's a Supreme Court opinion in Iowa that where the courts just do not like liability release forms at all. But that's not the situation in other states. So they might hold up in court unless you have a state court opinion that says that we're just not going to pay any attention to liability release forms. If they're executed, explain to the individual that at the time of execution as to what it means, they have an opportunity to read it. They can take it to a lawyer, have it evaluated, those types of things. If it's a take it or leave it type document, then the answer is probably courts are going to look pretty tough at that. But a recent case out of Texas brought this issue up, and it was a group that paid to go on a sunset horseback trail ride at a resort. They signed liability release forms that waived any claims against the resort. Well, they're coming back to the stable, and they have to go next to a golf course, and as they're right next to the golf course, an automatic underground sprinkler goes off, spooks the horses. One of the riders falls off. She's injured. She ends up suing the resort. The resort says, well, you signed a liability release form. And she said, well, we couldn't see this. This thing was hidden. It just pops up out of the ground and turns on right when the horse was next to it and scared the horse. And so that's not covered by the liability release form. The court said that the form used bold capitalized letters. It was in large font. The writer had initialed all those provisions. The form wasn't too broad. So it didn't only cover accidents caused by natural conditions. It also covered something unnatural like this. But again, I would warn, the outcome might not be the same in other states. So you have to be very careful when you sign a liability release form on both sides, whether the party that wants you to sign it has executed it properly, has had it prepared properly, and on your side, do you understand it? Have you had a chance to negotiate it? And what are the rules in that particular state with respect to liability release forms? But this was just another interesting case where a liability release form ends up in court.
Another case or situation I want to talk about. This happens to do with farmers in the Netherlands that are being told that because of the goal of net zero emissions of greenhouse gases and other so-called pollutants by 2050, they will be phased out if they can't adapt. But how you look at it is could that happen in the United States?
Well, the reason I bring that up is, a couple of reasons. We've seen what's happened in Sri Lanka in the past couple of years. We've seen the protests in the Netherlands, and now we've got Congress that's working on a farm bill And in the Inflation Reduction Act of last year, that funnels about $20 billion of climate funds into agriculture, but it comes with strings attached to it. And the fear is that could end up in policies that put similar pressures that we've seen in Sri Lanka and Netherlands on American farmers. And you've got these stats that are out there that say that ag emissions make up 30% of UTO's total greenhouse gases, will do so by 2050. And so there are groups out there that are putting a lot of pressure on policymakers to enact policies that would change the way that agricultural production occurs. But, Greg, as we know, energy security and ag production and food security are all tied to cheap and reliable and efficient energy. And so if you use less energy or less efficient sources of energy, you're going to have higher food prices, and people that are the least able to afford that will be hit the hardest. So the hope is, as the Farm Bill is written, that the writers of the Farm Bill will be thinking about these things.
Another interesting deal, this has to do, of course, with equity, in this case, equity theft, and this is from another Supreme Court case.
Yeah, this case came out of Minnesota. I think you and I had talked about it before the Supreme Court rendered their opinion. I know I'd written on this. And what happened was you had a homeowner who lost her home because you got behind on property taxes. And so that invokes the state law of forfeiture and foreclosure in that instance, and goes through that process. And the state sold the home at public auction, and it brought more than the tax debt. Well, the county just kept all the funds. They didn't just keep the money they needed to cover the tax debt. They kept her equity in the property. Case goes to the U.S. Supreme Court. Court said unanimously that's unconstitutional. That's a taking. Government, you're entitled to recover the tax debt, but the equity in the home goes back to her. And Greg, we've had cases, one in Massachusetts a few years ago involving an alpaca farm where this happened, and a ranch in Nebraska. Now the Nebraska Unicam changed the law there, so it won't happen again. But these other states that still have these laws that allow them to do this, there were about a dozen of them. They're going to have to change their laws now. So a good decision by the Supreme Court, unanimous on that one.
All right, Roger, that's amongst many topics of discussion today. And again, if people want more information coming up on a very busy time for you, and of course that's talking about your summer seminars, one later this week in Petoskey, Michigan, and the other one coming up in early August in Coeur d'Alene, Idaho. What's the best way they can find out more information?
Well, people can contact me directly, or they can find that information on my website. Also, through Ag Manager at K-State, there'll be information there about particularly the Idaho seminar.
All right, sounds good. Roger, as always, very much appreciate it. Safe travels up to Michigan, and we'll talk to you here in a couple of weeks.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he has been our guest on the Ag Issues program here on 580 WIBW.